Hi there, folks. Today we're going to start our discussion of the commerce power. So today we're going to make our way all the way up to just before the Great Depression and the New Deal. So first of all, let's talk about this commerce power. The commerce power is given to Congress. So why Congress? Well, we can see in Article 1, the Commerce Clause, says that the Congress shall have power to regulate commerce with foreign nations and among the several states. And so this gives a specific kind of power to Congress. So why to Congress? There are quite a few reasons, and some of these are going to ring a bell from your intro American government classes. First of all, there was a lot of chaos under the Articles of Confederation. And a lot of this had to do with the fact that states and even localities and various banks were issuing all sorts of different kinds of currencies. And this made it really difficult to organize some sort of reasonable trade outside of just these tiny little local areas. In addition, you had a lot of states that would engage in protectionism and other sort of one-off trade relationships, not just among neighboring states, but also with other countries. And this caused a lot of chaos as well. And one of the big problems that this introduced was the fact that the national government then couldn't use trade in its diplomatic efforts because the national government wouldn't be able to assure a foreign country, say, if you do this, then we'll open up our markets to you, because the national government didn't really have the power to do that. And then, of course, we had issues like Shays' Rebellion and all sorts of similar kind of episodes of unrest having to do with the policies of the states. And so all of these things encouraged this constitutional convention to center this power to regulate commerce to the federal government. And so when we're trying to figure out what this actually means in practice, there are a lot of questions we have to ask. First of all, we need to know what it means to regulate, and also what we mean by commerce. Now, this is going to be a really important theme coming up in the rest of today's video. We also need to know what it means for something to be within a state and what it means to have commerce that is interstate. And we also have to consider how this commerce power fits in alongside things like the Necessary and Proper Clause, the Supremacy Clause, the 10th Amendment, and so on. So now we're going to look at kind of the first cut on the commerce power, and this is in the case Gibbons versus Ogden. So you should have seen the little film about this case in Web Campus, and it's a great little flip. So if you haven't seen it yet, make sure to take the time to watch that, because it's going to emphasize a lot of sort of the subplots that were going on around this case. But I'll just summarize here. The material facts of the case had to do with steamships that were traveling between New Jersey and New York. Now, Ogden had been awarded a monopoly on this trade from New York. And his business partner, they have a falling out, and he leaves, but he takes along a federal monopoly over that same route with him. And so the question here is whether the federal permit supersedes the New York law that gave Ogden this monopoly to travel with his steamboats in New York. So the opinions in the case, the holding is a 6-0, and the answer is yes, that the federal law supersedes the state monopoly. And Marshall writes the opinion of the court. And he says, look, the commerce power is definitely broad enough to capture this kind of movement, because obviously interstate commerce includes navigation that is in commerce. So anything that is moving stuff or people from one state to another is part of commerce. Um, he brushes aside the idea that the 10th Amendment contributes anything to this argument because this isn't something that is left over for the states. This is an area of sovereignty that the states ceded to the federal government upon the ratification of the Constitution. Um, and that includes even the part of this navigation that happens within the state's own waters. Because part of that trip is interstate, then the interstate portion of it doesn't stop at the edge of the waterline, right? It continues all the way into the state's water. Now, there's another opinion here, a concurring opinion by Justice Johnson, and I mention this because it's kind of a really interesting opinion to read. And he's, I would just say, a little bit more forceful with his argument than Marshall is. And he says, look, this is the kind of thing that led us to the Constitution anyway. This is this kind of, one-off regulation that caused all of this disorganization and this lack of coordination in the economy before the ratification of the Constitution. And he also makes the point that it doesn't matter if Congress legislates in this area or if they don't. That the states don't have the power to legislate, even if the federal government decides not to do anything. And so he says, by common consent, those laws dropped lifeless from their statute books for want of the sustaining power that had been relinquished to Congress. So he's saying, look, once the ratification happened, then all of the state regulations having to do with commerce became essentially moot. They became powerless because they had all been superseded by the power given to Congress even before Congress had even used that power. Now, in Marshall's opinion, he mentioned this fact, but he declined to actually opine on whether or not this would be the case had the federal government not regulated it at all in this area. But Johnson disagrees with him on that point. All right, so the takeaways of this, we get our first cut at interpreting the word commerce, and here Marshall makes it clear that it does include navigation. And we also get, a first take on interpreting this among the several states. And Marshall makes it clear that it includes the part of commerce that happens solely within a state, provided that it is, linked to this chain of commerce. And also, it's a strong, another strong statement about the supremacy clause, noting that where there is a conflict, federal law is going to win. Now, what we're going to get to next is what happens when there isn't actually a conflict between the laws. So to get there, we're going to talk about some areas in which Congress regulated. So Congress regulated in a number of different areas, and the Supreme Court started trying to find the line. And so before the New Deal, some of the areas Congress tried to regulate were areas of monopolies and price fixing, prostitution, gambling, and child labor. So we're going to take a look at some of these cases today and get a sense of how successful Congress was during this pre-New Deal era. Now, I do want to take a moment to kind of refresh our understanding of some concepts related to constitutional and statutory interpretation that are going to keep coming up again and again. And so I want to remind you, this idea of formalism is a kind of perspective on interpreting the Constitution or statutes, and it prioritizes formal structures that are enshrined in the words of the law. So people who use a formalistic approach are largely unconcerned with the purpose of the law or the social impact that the law has. So whatever their strict interpretation is of the text of that law, that is what it is, regardless if it leads to sort of unusual or strange results. Now, functionalism is another way of approaching these issues. And this method prioritizes the goals that the law or the system was intended to achieve. And so it gives a little bit more flexibility in the approach in order to try to interpret it in such a way that it achieves the broader purposes that the law or whatever regulatory structure was put in place in order to achieve. Now, related to this is this idea of pragmatism. And pragmatism actually prioritizes the reasonableness of individual outcomes. And so here we see the law conceptualized as an instrument to achieve just results on a case-by-case basis. So this is kind of, you can kind of consider it being a little bit closer to functionalism, although the purpose of the law is sort of less important than is the actual reasonableness of the outcome. Okay. So we're going to see some examples of this as we continue through the video. Now we'll move on to trains and stuff. So we're going to start with the Shreveport rate case. And this is a really interesting case. It had to do with railroads in Texas. Now, the Texas Railroad Commission set really, really low rates on freight that was traveling within Texas borders. And these rates were actually lower than what the federal government had set for rates going across state lines. So the Interstate Commerce Commission was made aware of these low rates and essentially said, no, you can't do that. You need to bring these rates of freight traveling within the state up to meet the minimums established by the ICC for interstate commerce. So the legal question here is whether the ICC had the power to regulate those intrastate rates. The holding here is a 7-2 decision, and Hughes writes for the court. And he says, look, intrastate rates impact the market for interstate rates. So if a state sets the rates for intrastate freight shipping very low, it discourages customers from buying things that have come from other states. And so it essentially discriminates against those goods and products coming from out of state. And this is the way it has its impact on the interstate market. For this reason, Congress can regulate when a failure to regulate would harm interstate commerce. And so this argument, Hughes talks about the fact that it makes no practical sense to disallow regulation of intrastate rates when they have this effect on the interstate market, because this was the whole point of the law. So you can see here, this is an example of this sort of functionalist argument. Now, we have two dissents here, and these two just said, I dissent, and they didn't say why. But we could probably take a couple of guesses as to why that might be. What comes out of the Shreveport rate case is this thing called the Shreveport Doctrine. And the idea here is that Congress can regulate purely local commerce if and only if it has a substantial relation to interstate commerce. So this, if we take this, coupled with what we learned in Gibbons versus Ogden, we know that transportation counts as interstate commerce. So these artificially low rates for in-state freight impacted the transportation market across state lines. Of course, what happens when we're not talking about necessarily rates between states, but something that happens locally as part of the path of transportation? That brings us to Stafford versus Wallace. Now, this case had to do with the Packers and Stockyard Act of 1921. And the intent of this act was to try to ban unfair and discriminatory practices in the meat trade. And it also regulated transactions that happened in stockyards. And so this law was challenged, and the legal question was whether Congress has the power to regulate commerce that happens at stockyards. Because, of course, any given stockyard is in a particular location, a particular state. But the court holds 7-1 that yes, Congress does have this power. And Taft writes for the court, he said, look, this is how this market works. The cattle are in the west and they're moving eastward. They have to pass through a bunch of states to get there. And there are these places where they stop along the way, and there are sort of trades and sales and things that happen at these sort of pausing points that shape the rest of that trail of commerce. So any one stockyard is within a state, but it's just a stop on the way to the destination. And so the stockyards themselves are in the middle of a stream of commerce, and Congress has the power to regulate that entire stream. So even though what happens at the stockyard stays at the stockyard, I guess, it impacts this entire flow of commerce, and so Congress gets to regulate it. And then again, McReynolds dissents but declines to write an opinion. So the doctrine we get here is the stream of commerce doctrine. And this means that Congress can regulate purely local commerce if and only if it is in the stream of interstate commerce. So this isn't regulating the transport itself, but it's regulating what happens to redirect that stream at brief stops along the path of commerce. So this gives us a little bit more information about what we mean by the kind of commerce that Congress can regulate. But there's still a lot left undefined when it comes to the meaning of the word commerce. And so this is going to take us to this broader question. What do we mean? What counts as commerce besides this navigation or transportation? And the court deals with this issue in U.S. versus E.C. Knight. Now, this case had to do with the Sherman Antitrust Act of 1890. And so this act was an attempt, again, to fight monopolies and the ill effects of monopolies on consumer prices and that sort of thing. So the company E.C. Knight had sort of combined with a whole bunch of other companies and ended up with a 98% or so share of the sugar refining business in the United States. And the legal question here is, first of all, is the Sherman Antitrust Act an unconstitutional use of the commerce power? And if not, is it unconstitutional as it is applied to monopolies in manufacturing? So the majority holds 7-2 that no, this is not unconstitutional, but yes, it is unconstitutional as it is applied to manufacturing. And Justice Fuller writes for the court. And he said, look, in its domain of regulating commerce, Congress has all of that power, and the states can't interfere at all. So Congress can suppress monopolies of commerce. And this was obviously a monopoly of manufacturing. However, manufacturing is not part of commerce. So Fuller for the court says, it is vital that the independence of the commercial power and of the police power and the delimitation between them, however sometimes perplexing, should always be recognized and observed. For while the one furnishes the strongest bond of the Union, the other is essential to the preservation of the autonomy of the states as required by our dual form of government, and acknowledged evils, however grave and urgent they may appear to be, had better be borne than the risk be run in the effort to suppress them of more serious consequences by resort to expedients of even doubtful constitutionality. So this is interesting, right? What he's saying here is, look, our main job isn't to come up with good answers to social problems. Our main duty is to read the words in the Constitution and create whatever impenetrable firewall we think those words require. And even if this leads to pretty terrible results, that's not our problem. We can't help it. It would be better to risk that problem than to risk anything that's even close to the line of giving Congress more power than we think the Constitution allows. So this is obviously an example of formalism. So Harlan dissents in this case, and he's not impressed with this kind of formalistic approach to interpreting the boundaries of the commerce power. He says, look, this attachment to this so-called meaning is really counterproductive because this keeps the whole commerce power idea from achieving the goals that it was supposed to achieve. He said, look, even Justice Marshall said this in Gibbons versus Ogden, that the whole point is to protect this freedom of trade. And he said, look, manufacturing monopolies, they ruin free markets and competition just as much as transportation. And this idea that somehow there's this brick wall between manufacturing something for interstate commerce and then actually moving it to the next state, that's just a completely artificial distinction. He says, look, in what world is this not commerce? So in the opinion, he notes, the common government of all people is the only one that can adequately deal with a matter which directly and injuriously affects the entire commerce of the country, which concerns equally all the people of the Union, and which, it must be confessed, cannot be adequately controlled by any one state. Its authority should not be so weakened by construction that it cannot reach and eradicate evils that, beyond all question, tend to defeat an object which that government is entitled by the Constitution to accomplish. So this is very obviously a functionalist kind of approach that also, he's using a functionalist argument here, but he's talking about the fact that this is real social consequences, and it makes no sense to put these very, arbitrary and strict lines around the outside of the commerce power when the whole reason we ended up with the commerce power to Congress in the first place is to prevent stuff like this. All right. So it turns out that he doesn't win the day, but there are a couple of other interesting cases where the Congress attempts to regulate things that are commerce-like using something like police powers. So let me explain. What we're talking about here is this idea of regulating morality, or things having to do with moral decisions, in the name of commerce. So using the commerce power to accomplish goals that have to do with morality. So this is some sort of mix of commerce-like topics that have these police power-like connotations. So when we talk about police power, we mean the power to regulate health, safety, morals, and the general welfare of citizens. And this has traditionally been seen as the state's domain. So now we see the federal government also addressing some of these questions through the commerce power. And some of the topics mentioned in the book that Congress attempts to tackle using the commerce power and things like prostitution, gambling, and child labor. So we're going to take a look at a couple of these here. First, let's take a look at these lottery laws. And the case we're going to talk about is Champion versus Ames. And in this case, Congress had prohibited the sale of lottery tickets across state lines. And Mr. Champion was arrested for attempting to transport lottery tickets across state lines. So he files a habeas corpus petition challenging his confinement because he doesn't think that Congress has the ability to regulate this. So the legal question here is whether transporting lottery tickets is commerce under the meaning of the Commerce Clause. And the holding is 5-4, and the answer is yes. Now, Harlan writes for the court, so this might give you some sense of the direction this is going. He said, look, limiting the transport of lottery tickets is just commerce, right? We already know that transporting stuff between states is commerce, and Congress gets to regulate that. So states can have lotteries if they want. Congress isn't banning that. It's just that they can't sell their tickets across state lines, because that's where the federal government comes in. And so he says, the whole subject is too important, and the questions suggested by its consideration are too difficult of solution to justify any attempt to lay down a rule for determining in advance the validity of every statute that may be enacted under the Commerce Clause. So here you can see that Harlan is making it clear that he is concerned with just this particular question in the case, that he's not intending to sort of extrapolate from this some sort of grand, universally applicable definition of commerce. He's just saying the question in front of us is about these lottery tickets. These lottery tickets are commerce. If you got a question about something else, well, bring it to us and we'll decide that. So this is this kind of one at a time, case by case determination that is a very pragmatic approach. All right. Now, Justice Fuller writes for the dissenters, and he says, look, okay, we know from Gibbons versus Ogden that transporting stuff is commerce. But come on, Congress wasn't trying to regulate transportation. Congress was trying to keep people from gambling. That is about morals, right? The federal government does not have the police power. This is the domain of the states, and the states get to regulate this. Congress can't come in and ban something under the commerce power just because they think it's distasteful, all right? But again, he doesn't win the day. Now, there's one other case having to do with the police power, and this has to do with child labor. This is the case of Hammer versus Degenhardt. You can see there's our decision split up there. The facts of the case are this. There were a number of states that had attempted to regulate child labor and sort of ban child labor in kind of certain instances and degrees. However, it was very difficult for this to be a state-by-state solution, because if one state put this limitation on their businesses and another state didn't, then the state that prohibits cheap child labor ends up at an economic disadvantage. And so it ends up being one of this kind of example of a race to the bottom. So the federal government passes the Keating-Owen Child Labor Act, and this act prohibits the shipment of goods that were produced using child labor, and it defines child labor by prohibiting workers under the age of 14 and limiting the hours and days worked by kids who were between the ages of 14 and 16. So Mr. Degenhardt sues on behalf of his kids and their right to work in a cotton mill. So dad of the year there, I guess. The legal question in this case is whether this Keating-Owen Child Labor Act is beyond the power of Congress under the Commerce Clause. The holding here is a 5-4 decision, and the court holds that yes, banning child labor is beyond the power of Congress. Now, don't worry, spoiler alert, this case gets overturned later. But we're ending our discussion here right before the New Deal, and so at this point in time, the court held that Congress does not have the power to ban child labor. So, yeah. So Justice Day, he admits, yeah, I mean, child labor's bad. It's probably not a great thing. But the effect of child labor is like, I don't know, it's bad for kids, and kids like live in a state, and so the effect of child labor is local. So this means that the states have the power over it, not the federal government. And the fact that regulating child labor puts any one individual state at a competitive disadvantage unless all states engage in this kind of regulation, well, sorry, too bad. So Day writes, this court has no more important function than that which devolves upon it the obligation to preserve inviolate the constitutional limitations upon the exercise of authority. So this is an incredibly formalistic argument, right? We're talking about little kids working in factories. And he says that's not our most important consideration. Our most important consideration is monitoring and policing this imaginary line, or I guess this line that is somewhat arbitrary, that is a boundary around the commerce power. Now, Justice Holmes writes for the dissenters, and he's not impressed. I mean, he was kind of a paraphrase. Basically, he's saying, y'all are terrible, right? This is little kids we're talking about. And so here's an example, a small excerpt from his dissenting opinion, talking about the Keating-Owen Child Labor Act. He says, the act does not meddle with anything belonging to the states. They may regulate their internal affairs and their domestic commerce as they like, but when they seek to send their products across the state lines, they are no longer within their rights. If there were no Constitution and no Congress, their power to cross the line would depend upon their neighbors. Under the Constitution, such commerce belongs not to the states, but to Congress to regulate. It may carry out its views of public policy, whatever indirect effect they might have upon the activities of the states. So there's a lot to unpack here. First of all, he's arguing that this arbitrary line that they're placing around this boundary of the commerce power doesn't make any sense, right? That the commerce power was enacted in order to prevent this kind of collective action problem among the states. And he shows that, this line is arbitrary. But at the end, he talks about the fact that there is this public policy concern, and states aren't going to be able to achieve this on their own. And so this means that it is absolutely fine for Congress to carry out its view of public policy when it has to do with stuff that is going to go into interstate commerce, right? Now, we do have an epilogue here. And this is a quote from a few years after the decision, an interview with Reuben Dagenhart, who is one of Mr. Dagenhart's kids, who won the right to work in the mill. And he was asked if he benefited from winning this case. And he said, I don't see that I got any benefit. I guess I'd have been a lot better off if they hadn't won it. Look at me, 105 pounds, a grown man, and no education. I may be mistaken, but I think the years I've put in the cotton mills have stunted my growth. They kept me from getting any schooling. I had to stop school after the 3rd grade, and now I need the education I didn't get. It would have been a good thing in this state if that law they passed had been kept. And that's a quote from Reuben Dagenhart. So this is where we leave off, and we will be back next time with the Commerce Clause and the New Deal. Thanks a lot.